Hello all. Good afternoon. My name is Dov Shamir. I'm the Manager of Entrepreneurship here at Mount Sinai Innovation Partners, and welcome to our legal primer with McCarter English. Before we get started, and I introduced our esteemed guest from McCarter English, Jared Soren, I just wanted to go over some ground rules and give you some context on where we're at with this primer series as part of our entrepreneurial educational series at Mount Sinai Innovation Partners. So in terms of ground rules, regarding questions or comments, please use the chat window that you can use. Use the function on your keyboard called Alt-H if you want to open it up. Plus, Zoom makes it pretty easy to find that function as well. We'll be fielding all questions via the chat, and I'll be asking Jared the questions during the Q&A at the end. Okay, so in context, this primer series, or this primer I should say, is part of our greater Pitch Challenge program and entrepreneurial programming here at Mount Sinai Innovation Partners. We have been working with inventors and innovators at our institution for about almost a 7-month period now, since September-August time. Hold on, we got one comment quickly. Sorry about that. In terms of everything from, we've been working in terms of ideation, learning about design thinking, how emerging technologies can contribute to healthcare and biotechnology development. Basically the full spread of educational as well as workshop needs to get our inventors through this process. We've had workshops with New York City Media Lab, and we right now have 10 teams, all of which have presented their solution in some shape or form, whether it be the Mount Sinai Hackathon, the Innovation Showcase, or the poster competition, which was a couple weeks ago. The starter primer here fits towards the end of our programming because now our participants of the program have figured out a healthcare problem that they want to solve, put together a healthcare solution that they essentially have ideated a solution, and have now put together a prototype of that solution in some shape or form. Now is the time to start figuring out a business case around that solution and where they can actually apply that solution in a commercialized plan. Now, we have a very unique perspective here at Mount Sinai Innovation Partners in terms of how technologies in the healthcare space are commercialized. And we're not a typical tech transfer office. We see all commercial opportunities on the table, and we will work out ways to license those technologies either to existing or new startup companies. This Pitch Challenge program will culminate in the Pitch Challenge itself, which 6 teams will compete for a cash prize. And basically that cash prize will get them from the point of a late prototype to a minimum viable product, which will help them either license the technology or get them to that next major inflection point. The sponsor of the Pitch Challenge program is McCarter English. They are a great law firm within the New York City area and on the East Coast, involved in all things innovation and entrepreneurship. And we thank them for sponsoring this series as well as contributing to this particular primer. And we are happy to have them as part of our ecosystem. So just a little bit more about Mount Sinai Innovation Partners. We're the commercialization office of the Mount Sinai Health System, which means if you have any an idea, an invention, a technology in which could be commercialized, our office is the one that helps translate that technology for real-world applications, both for our patients and society as a whole. We are at the intersection of the School of Medicine and the hospital, and that of existing or new companies. We have many different functions, which some I'll go into in a few moments, but 3 that you should be thinking about in terms of this particular primer is in technology acceleration, entrepreneurship, and startups. When it comes to startups and new ventures, Mount Sinai Innovation Partners has a very deep history in creating ventures that are impactful and are successful and have kind of moved beyond just the institution and purely the clinic or the lab. These are some great examples, with most of which are in the last couple of years, with the exception of Semaphore, which is a little older. But all are great examples of what we're looking at towards a mature venture that's being spun out of the institution. I believe almost all of these ventures have some Mount Sinai employee that is potentially a founder or has some major connection to the company, whether it be part of the founding team. The technology they invented is a seminal piece of the platform in which the venture is bases their platform on, et cetera, et cetera. Traditionally, these ventures have been created by veteran scientists and clinicians. These are some values in which the funding values that these ventures have put together, have raised in their lifetime. I think they're pretty up to date. They're either from PitchBook or Crunchbase. But you see they vary in terms of size, and it really depends on also the size of the opportunity, as well as the team that's being put together to put these ventures in place. And at MSIP, we help in that process when there's a launch. Two great examples of that are Renalytics AI and HyperCell, and with that launch both within around the last 2 years or so. Renalytics AI is a kidney and renal disease diagnostic and prognostics company that was launched off of the London AIM with a $29 million raise. HyperCell is a drug discovery company focusing on cancer metastases and dormant cancer cells, basically creating therapeutics along those lines. And all the rest here cover a broad spread of different industries. We have IT, digital health, we have traditional therapeutics, telemedicine, and different devices as well. Now, for many of you in the audience here, you may not be at the point of a venture that's ready to launch with funding from venture capitalists or other funding sources. Most are in some form of incubation. Most are in the early stages and conceptual at best. Most of these emerging startups that I'm showing you as an example are in that conceptual stage. And they're great examples of what we see as validating a business model, creating a technology from literally just an idea, and it's probably a more traditional, or I should say it's more of a typical route for many of you in the audience. The ventures that you saw before here, are some exceptions to the rule in many cases, but it's what we want to achieve for all our spin-outs essentially. Each one of these emerging startups has had many accolades, particularly in the entrepreneurial incubator and accelerator ecosystems. Retina Technologies, for example, competed and was a finalist in the New York City Media Lab Combine. Mitral Print was a finalist in the Columbia Venture Competition, and Metascribe was a finalist in the eLab New York City competition. Lab 11 Therapeutics won the 2018 JLabs Quickfire Challenge in New York City here, and Demeter and Walkthrough both participated in our innovation showcase, as well as were finalists in the hackathon. So, again, this is kind of where the base of where many of these ventures and startups begin, kernels of ideas, and each one of these at this point, or let's say most of them, have gained follow-on funding going forward, have found partnering opportunities, and have moved their technologies forward beyond early prototypes, and now it's something that has a higher potential of being commercialized. Whether it be an emerging startup or a venture, each one of these teams started in one place, and that was disclosing their technology to our office. And by doing so, you can engage our full plethora of services, our business development team, finance and ops team, transactions team, intellectual property team, entrepreneurial marketing and outreach team, and basically it's a full spread of services that allow the technology and the inventor to learn and grow and make an impact on healthcare. Once you get through the disclosure in phase 2, our office will evaluate the technology based off of several commercial, technological, as well as intellectual property points. And if it's accepted into our portfolio, we'll then incubate the technology, running it through the different groups I just mentioned, in essentially in an intertwining process where we'll help grow the technology, market the technology, help you validate the technology, put in our business development team into the process, find ways to protect your technology, whether it be patenting it or some other intellectual property strategy. And we also obviously provide all the entrepreneurial programming as well. And through this process, it's been shown that you can increase the success in validating the technology, finding those first customers, and potentially raising capital depending on what the commercial endpoints are. At the end of the day, through our pipeline, through this incubation phase, we'd like to see the technology either being licensed to a startup or an existing company in most cases. And ultimately, it'll be one of those two entities, which Jared will go into specifically today about a startup entity, of how those concepts are commercialized going forward. So once that happens, those companies take the technology going forward and commercialize it so it could be scaled up for societal use. Now, our inventors have an option to share in the profits or say the profits of their inventions. And we have a pretty competitive revenue distribution plan in New York City, one of the better ones. Under $1 million in revenue is 50% to the inventor, 50% to the institution. Above $1 million is 33% to the inventor, the rest to the institution, and 5% in both cases to your inventor research fund. Now, like I've mentioned already, the benefits of working with our group definitely outweigh the costs, and the technologies in which I've been talking about this whole time fall under our IP policy. And this basically stipulates that Mount Sinai owns all inventions conceived or reduced to practice or otherwise made by the Mount Sinai member. So basically, if it's an invention that's within the course or scope of your employment, you've used Mount Sinai resources or Mount Sinai's administered funds towards that invention, it follows under our IP policy. And just coming from a personal perspective, when I was a grad student at NYU, I actually had the opportunity of seeing this, that NYU's policy in place regarding my thesis technology that I was creating, as well as a personal invention that I was creating. And I can tell you right now, I could have went on my own with the personal idea, and I would have not gone this far. When you have a big institution working with you, it's very impactful, it's very helpful, and when you come to the table with essentially a team, and that's what you're doing when you're working with MSIP, you're essentially going to the table to all the industry partners with a team, and that says volumes when you're trying to commercialize something. You need again, many of you on the line are academics. You need to be able to collaborate with someone in order to get a project going, and collaborating, working with us is the best way to do so in order to get technology out the door. In addition, if there's any commercial activity in terms of your research or otherwise for your own career here at Mount Sinai, and this comes in very handy if you're thinking about putting together a startup with our group, you need to go work with the Conflicts of Interest Office in order to identify, mitigate, and manage potential conflicts of interest. And they'll help put together a strategy in place for you to essentially minimize risk and exposure, and making sure that you meet your employment agreements, and that everything is on the up and up. I put their contact information on the bottom if you'd like to reach out to that office. So now if we just, last stage here, if we now take all that in mind, the COI, the IP policy, etc. So in that incubation stage, if you're thinking about putting us, again, if MSIP, while working with you, finds that the startup option is the best commercial route for the technology, that will typically happen in the incubation stage. And again, more likely the case is you're going to have it as a company concept initially. And if that company concept is further validated and we find that there's investors or there's good feedback from those investors, and again, we might help put together, actually form the company in some fashion. And later on, as licensing the technology is put in place, there might be a term sheet that we typically do for any license. Now, just to reiterate, throughout this process, unless you plan on leaving Mount Sinai, inventors here are typically under the IP policy because you're employees, and that's throughout the whole process. And I just want to reiterate that because some of Jared's talk is going to go into assigning technologies, and just so all of you know, again, as Mount Sinai employees, you're still under our policy. And again, there are some nuances to how that might work with the startup. So with that, I will leave it to Jared and the McCarter team and to give us the legal essentials for startup founders.
Amazing. Thank you, Dove, and thank you to Mount Sinai for this opportunity. This is an exciting conversation to have. For background, this is Jared. I work with startups, early stage and emerging growth companies and the investors who support them in and around New York. So McCarter is a full-service law firm, but my particular focus is on representing these early-stage companies, literally from ideation, napkin stage companies, idea stage companies, through the various rounds of capital raising transactions, through maturity and monetization, or other M&A type acquisition or exit. McCarter English is different than the traditional law firms that you might be familiar with. I won't bore you with too much of a commercial here, but we are born in order to serve these early stage companies. And so as a result, we have changed the business model of lawyering in order to provide a delivery model that actually makes sense, where you'll be getting experienced lawyers who are not learning on your nickel at a fee structure that actually makes sense given the stage of company. We'll leave it there, get right into it. If anyone has other questions on that, I'm happy to field them at any time. I think given the fact that we are via webinar here, it might make sense to answer questions towards the end. But if there is something that I say that's not clear, if you throw it in the chat, if I notice it, I will answer it. Dove will also be monitoring that, and we'll make sure that we answer as many questions as we can. So with that, why don't we dive in? Dove, would you mind jumping to the next slide, please? All right, so question number one, when you're deciding to start a company, is what is the right entity of choice? There are so many options, but really three good options for the companies that I assume most of you are contemplating creating. Those are the C Corp, the LLC, and the S Corp. Broadly, a C Corp is a standalone entity separate and apart from the individual owners. It is the entity of choice for the institutional investors that you might look to raise capital for. It has certain benefits from a tax perspective that we can get into later. And there's this thing called QSBS eligibility, which I'll get into. For now, know that any one of these entities provides what's known as limited liability protection for the owners. So that's really important if you want to protect your personal assets when you're creating a company, which undoubtedly you do. Each of them provides liability protection so that you are not liable personally for the obligations of the business so long as you operate truly as a separate standalone business. So a C Corp is the garden variety corporation that most startups form. Conventional wisdom used to be that, and still is to a degree, that you form as an LLC or a limited liability company first, and then when your investors require it, you convert to a corporation. That's actually not our typical advice for companies that are technology companies, and I'll get into that in a moment. But generally speaking, as it says up here, LLCs are not acceptable to institutional investors because an LLC is a tax pass-through entity, which means it is effectively a disregarded entity in the eyes of the law, and the taxes flow through to the individual members who own the LLC. Now, if you're an early stage company and have losses, as many early stage companies do, and you have other forms of income, you might benefit from the tax pass-through elements of an LLC because you can offset your other forms of income with your early stage losses on your personal tax returns. That sounds great, and oftentimes is great, but enter QSBS, Qualified Small Business Stock. So in 2016, Qualified Small Business Stock was made a permanent part of our tax code pursuant to the Jobs Act. And what it essentially means, and I'm going to grossly oversimplify for my benefit, not yours, because I'm not a tax lawyer, but it essentially means if you hold stock of a qualified small business, which is essentially a C corporation with assets less than $50 million, and you hold those shares for a holding period of not less than 5 years, when you sell your stock, you will get your gain at up to 100% federal tax-free rates for the first $10 million per stockholder or 10 times your cost basis in the stock. So what does that mean? If I form a corporation today and I sell my stock, and it's a qualified small business, and I sell my stock in 5 years and 1 day, if I sell it for $10 million and I'm the sole stockholder owning 100% of the company, I will pay no federal tax on my gain. That is a potentially massive benefit that is only available to C corporations and to holders of actual equity. So that's common or preferred stock. We'll get into things like stock options and convertible notes or safes later on in this presentation. But for now, let's just remember that those types of securities do not meet the QSBS holding period until they actually convert into common or preferred stock. So if you're the founder of an early stage company, you have to think really hard about whether the short-term benefits of an LLC tax pass-through or the long-term benefits of meeting your 5-year holding period, which one provides you with the better sort of bang for your buck. And if you are like a prototypical startup and you expect to sell the company in somewhere between 5 and 10 years, I think many companies rationally come to the decision to form it as a C corporation, get that 5-year holding period started, rather than risk missing out on that potentially massive benefit. So that's C Corp and LLC. I note here, if we could just go back for 1 second, I note here that equity swap transactions are taxable if you're an LLC. Very briefly, what that essentially means is if you sell to an acquirer for equity in that company, that is a taxable event if you're an LLC. So all you receive is equity in another company, but you have a really large, potentially tax liability with no cash coming in the door to offset it. That's a bad tax result, which doesn't exist if you're a C corporation. The tax is deferred if you're a C corporation until you sell the stock that you've recently acquired. Okay, moving on. I'm going to skim this one because this is just a lot of information. Essentially, the first bullet is, where should this entity be formed? Now, I imagine many of the people listening today are based in New York, but generally speaking, our advice is to form under the laws of Delaware, even if you have no physical nexus to the state of Delaware. And the reason for that is not so much legal as it is practical. Delaware law is very well established, but even more than that, investors know Delaware law, they like Delaware law, and they are creatures of habit, and they like what they're familiar with. So it's usually a condition of the investors, institutional investors in particular, VCs, et cetera, to form pursuant to Delaware law. If you've already formed an entity and it is not in Delaware, not a huge problem, not a problem at all, I should say. What we would generally do is convert or merge that entity into a Delaware corporation as a condition precedent to the investors investing their money. This organization process, do it right the first time, sounds easy to say, harder to do, but the reality is that there are mistakes that can be made in the early stages that can have long-term negative effects on the company. We'll get into some of them as we go, as I share maybe some horror stories of companies that I've worked with in the past. But suffice it to say for now that much of this is form-based, right? We're not recreating the wheel every time we do an incorporation. I'm making this number up, but let's say 75 or 80% of the documentation is retread based off of previous models. That's not what you pay your lawyer for. It's the 20 or 25% that is unique to your business, that's important, that can have really critical impacts on your ownership and the value that you actually receive from owning this equity. Starter kit, this is what we would call like our incorporation set of documents. I won't get into it now because much of it is covered later on, but in a corporation, there's roughly 15 to 20 documents in our typical starter kit. In an LLC, it's less than that. Moving on, please, Dove. Okay, protecting intellectual property, and Dove mentioned this a little bit already. Your intellectual property is likely your most valuable asset at the early stages of the company, especially, aside from your human capital, right? And there are many ways to protect your intellectual property, and it's not just patents. So many companies think that they have to have something that's patented or patentable in order to attract investors. And the reality is that that's just not true. For one, patents are not available to most technologies. Patents only protect inventions or new ideas. And you know, it's really difficult to get patents for things like software, etc. So patents can be expensive. They can take a very long time, and they just may not be available to your company. And so we think about other ways to protect intellectual property, especially in the early stages when cash might be strapped. And you're bootstrapping, you have to allocate resources as efficiently as possible. And you may not have a tremendous amount of money to protect your intellectual property through things like patents. The best way in the early stages to protect your intellectual property is through contract. Right? We create things like invention assignment agreements and confidentiality agreements. You see at the bottom, work made for hire agreements. There are very few times in the law where there are truly magic words. Work made for hire is one of those situations where there are magic words. Essentially, the long story short is, if you're a company and you hire an employee and the employee creates intellectual property for the company, very similar to what Dove said earlier, the intellectual property is owned by the company so long as it was using company resources within the scope of the company's business, et cetera, et cetera. That said, you still want to have any employee that you hire sign an invention assignment agreement. The law is a little confusing here. It is exactly the opposite when it comes to consultants. So the rule is, absent an agreement to the contrary, he or she who creates it owns it. That's a very bad result if you're the company and you bring on a consultant to create whatever intellectual property for you, whatever code or whatever else this person might create for you. The rule is that person owns it. The company simply has a right to use it. And obviously, from the company's perspective, that means that this person can go and compete with you, can sell to one of your competitors. Not a good result, and investors are not going to like that. Acquirers are not going to like that. So horror story number one, I guess. We represented a company maybe 3 or 4 years ago on their acquisition. And I like to make it clear that we did not represent them before that for a reason that'll become obvious in a second. That company grew in a matter of a couple of years from nothing to about $100 million, had an acquisition offer for $100 million. Our founder owned about 95% of the company. His father owned about 4% of the company, and employees and consultants owned about 1% of the company. This founder had made the affirmative decision to never seek invention assignment agreements because it was an awkward conversation that he didn't want to have. And this was a really bad decision. This acquirer did its due diligence, And one of the first questions any acquirer will ask is, let me see, or will you please produce the invention assignment agreements for every employee and consultant since the company's inception? Our founder couldn't do that, and the acquirer basically said, this is going to go one of two ways. You are either going to go and get them. Every current and former employee and consultant will sign an invention assignment agreement, or we will have no deal. So we have a potential $100 million deal on the table that is about to die over something that, done right and done when onboarding an employee or consultant, almost invariably will be signed. Our founder had to go to current and former employees and consultants, ask them to sign invention assignment agreements. For one, that was difficult because it's hard to track down certain employees and consultants who no longer work with the company, and even harder to convince consultants who no longer work with the company to sign an invention assignment agreement because, as I said before, they own it. The company simply had a right to use it. So they had no incentive to sign this invention assignment agreement. And so our founder effectively had to pay $10 million of the purchase price to these current and former employees and consultants in order to buy invention assignment agreements. I mentioned this before. This is something that when onboarding someone, you're giving them a job, you're giving them equity, you're giving them a salary, whatever the case may be, they will almost certainly sign it, and it's par for the course. So this was $10 million that belonged in the founder's pocket that he ultimately had to give away. Now, he obviously did really well for himself nonetheless, but it was an expensive mistake. So good general corporate housekeeping, have invention assignments signed by every employee and consultant that you hire. To Dove's point from earlier, if you are employed by Mount Sinai or others, if they are employed elsewhere, should think about and understand their policies. And to the extent that you do ultimately leave the employ of a previous employer, you as a founder and any employee and consultant that you sign should have signed any invention that's developed for your company to the company. Special issues for employer ownership rights and university licenses. Dove went into a lot of detail here, so I won't. But if the technology does emanate from a university, understand that they likely do have ownership rights. And in order to commercialize that IP, the university may very well grant the license in order for the company to commercialize. And then when you think about that, I think we might do this in a separate primer, but things to consider are exclusive versus non-exclusive licenses. What is the field of use? What is the payment to the university? Is it equity? Is it royalties, etc.? Very important and not something that can be overlooked. Next slide, please. All right, hiring and incentivizing employees, including the co-founder. We'll do this slide pretty quickly, but I mentioned before, in the early stages, companies have to allocate cash resources as efficiently as possible. And how do you attract really quality employees at a time when you can't pay them market rates? The typical way to do it is through something called an equity incentive plan, where you grant equity in the company to employees or consultants in order to incentivize and to attract and retain really high quality talent. And so the typical way to do that is through something called an option award agreement or restricted stock. If we grant options, an option is essentially the right to buy stock in the future at a price that we're setting today. So if you're a startup company, you want to bring on an employee, and the value of the company today is nominal value, 0.0001 cents per share is the par value that we would normally set up for a startup, like a true raw napkin stage company. You can grant them an option at an exercise price of 0.0001, and they can exercise that option according to certain vesting milestones. That way they are motivated, incentivized to stick around, and handcuffed to the company. If you're an employee, you would get an incentive stock option. That's what this ISO is, an ISO. Those are available only to employees of corporations. I won't bore you with too much detail now, but they have favorable tax benefits to the employee. Non-qualified stock options are any option that is not an incentive stock option available to consultants, non-employee directors, etc. Restricted stock is stock that is owned today but subject to a company repurchase right. And that's something that we would suggest even the founders agree to. So I mentioned in the second to last bullet there, founder stock, vesting, forfeiture, repurchase rights. If you are one of multiple co-founders, you want to make sure that your other co-founders are in this for the long haul, right? A startup takes a long time, and it's a very, very deep investment, right? It's a lot of work, and you need to make sure that people are in it for as long as it takes to make this successful. So when we have multiple founders, we very strongly urge that these founders take their shares pursuant to something called a restricted stock purchase agreement. That means they own the shares today, they are stockholders, they vote their shares as a stockholder, but the company has the right but not the obligation to buy back those shares if the founder leaves for whatever reason. So the typical vesting schedule today is a 4-year vesting schedule with a 1-year cliff, which essentially means that 100% of the shares are restricted at the time of grant. On the 1-year anniversary of the grant date, 25% will vest and no longer be subject to the company repurchase right. And then for 36 months in roughly equal monthly installments, the remainder will vest so that the founder is fully vested on the 4-year anniversary. Again, that handcuffs the founders to the company, ensures that they are going to stick around, and aligns incentives among the founders. Very important is if you are a founder and you do take your shares pursuant to a risk of forfeiture, the IRS will not tax your, as a default rule, the IRS will not tax your shares until the risk of forfeiture lapses. That's a very bad result if you're a founder taking your shares at par value, because hopefully the shares will be worth way more when the risk of forfeiture milestones lapse. So if you remember one thing from this topic, please remember 83B elections. 83B elections are effectively a bet with the IRS. You're saying, I will bet you that these shares will increase in value, and I will pay the tax today at the current value, even though there's a risk of forfeiture. And if the value goes up, you win the bet. If the value goes down, the IRS wins the bet. If you're a founder and you take your shares at 0.0001 cents per share, the par value that I mentioned earlier, you're almost certain to win that bet. And there's really no downside to losing it because you're paying a fraction of a penny per share. So 83B elections is an affirmative election that you must make with the IRS within 30 days of the date that you're granted your stock. This is one of those hard and fast rules where there is no cure for a failure to timely file. So please, if you take your shares pursuant to a risk of forfeiture, you must file within 30 days. There is no good cure. There are Band-Aid cures that we can discuss, but frankly, none of them is perfect. The last slide is sort of just the last bullet here is sort of just a throwaway fun one. Many companies bring on interns or others who they think that they don't have to pay, but minimum wage laws apply. Especially in New York, there are some really stringent minimum wage laws. There are some exceptions for founders and stockholders of a certain percentage of a company, but please do understand that you must pay minimum wage, and if you don't, there could be penalties for that, including back pay and penalties to the state. Moving right along. Okay, the next topic is raising capital, and this is a big one. Obviously, we want to start with why would we raise capital at all? And if you are a company that doesn't need to, or a founder that doesn't need to, it might very well be in your interest not to, because as soon as you raise capital from outsiders, you open the company up to other perspectives, right? If you are the sole stockholder, no outside investor or others on your cap table, what you think is in the best interest of the company goes. Obviously, you have to act in good faith in accordance with whatever fiduciary obligations you may have. But generally speaking, so long as you're operating in good faith and in accordance with your best business judgment, you are the sole founder, sole stockholder, sole director, and you make the strategic direction decisions for the company. Now, the reality is for most startups that we don't have the luxury of endless and deep pockets, and so we must look to raise capital from others. And so the next question is, from whom might you raise it? I mentioned this a little bit, but bootstrapping, the first step, if you think about this as sort of the rungs of a ladder, bootstrapping is the first rung, the bottom rung, which is sort of confusing from the way the slides look. But bootstrapping, reaching into your own pockets, self-funding to the extent possible. Now, I like to say here that that does not mean taking out a second mortgage on your home, risking all of your personal assets. We hear sometimes about the founders who risked it all and won. You hear very little about the founders who risked it all and lost, which are obviously far more prevalent than the founders who were successful in doing this. And if I'm an investor and that's how you're spending your own money, I'm going to question how you're going to spend my money, and I'm going to be concerned. So yes, you should certainly reach into your own pockets to the extent you can. You should, put sweat into this business to grow the business to the extent possible before looking to outsiders. But that does not mean run the risk of losing all of your money and your financial stability and your family's financial stability. Accelerators are a great source of not only financial capital, but even more than that, intellectual capital. These are people who are very well connected into the ecosystem. Accelerators make a lot of sense for first-time entrepreneurs in particular, who may not already be tapped into that ecosystem. Accelerators, generally speaking, look for a relatively small equity stake in a company, and in exchange provide some capital, not a ton, but also mentorship, guidance, the network, etc. Friends and family, and jokingly we throw up fools on there. Friends and family are a good source of capital for some, right? One, it's, do you have friends and family who have that kind of money, who are sophisticated investors willing to make an investment like this and understand the risks of doing so? And if so, are they the type of people that you want to take money from? Now, I've seen a few horror stories here as well, where people have raised money from unsophisticated friends and family who may not have understood the very long time horizon for growing a successful early stage company, thought that they'd get their money out much quicker than they actually do, or lost the money and may not have had the ability to withstand such a loss. So friends and family can be a great source if they're sophisticated, if they understand the risks associated with an investment like this, and if they are the type of people who understand that because they've invested a relatively small amount of money doesn't mean that they get to control your business. Right? Some of the horror stories you hear about are losing grandma's retirement fund, or your uncle who now thinks that he can tell you how to run the business because he put $5,000 into the incorporation. These are bad situations that can hurt familial relations. So be cognizant, be careful, but potentially a really good source. Angel investors and angel groups. These are investors who are typically high net worth individuals or collections of high net worth individuals who invest together. Usually they invest in things that they have a particular expertise in, and they see this One, as a way to make a financial investment and get a return, but also as a way to sort of take the next steps in whatever technology they made their fortune in and grow it into the newest technology. A really great source. I mentioned that this is sort of like a ladder with rungs, but there is most certainly a blurring of the lines, I think, with respect to some of them. We often see angels investing alongside venture capitalists, alongside corporate partners, because some angels have gone up market to where the VCs historically played, and a lot of VCs have come down market to where the angels used to play. And we'll get into pre-seed preferred stock and early stage venture funds shortly. So that's angel investors. Venture capitalists are investors who make their living investing in early stage companies. They look for that type of company that can have that hockey stick growth, that explosive scalability, et cetera. Know that when you bring on VCs, you do give up a significant level of control, generally speaking, because VCs will ask for certain control protections. Now, that doesn't mean that you're giving away affirmative rights to the VC to control the company or to act on behalf of the company. More typically, it means that the VC will have a veto right over certain actions where they can prevent you, the founders, from acting. So venture capitalists, corporate partners, we're seeing a ton of corporate partners. A lot of corporations invest in early stage companies because it creates a pipeline for them, because it's easier to invest in an early stage company who's doing something analogous to what they are doing than it is to recreate it on their own. But no, with corporate partners, done wrong, it can be troubling. You don't want to enter into a corporate strategic arrangement with a corporate partner and have the terms basically set a valuation that will never be able to be met by another investor, or you run the risk of being orphaned if the corporate partner decides that there's a different, better technology out there, or if they change their interests generally. And also, you run the risk of de facto selling yourself too early if the deal documents are structured in a way that prevents you from selling to competitors or others. So you want to avoid making yourselves unsaleable to others. But having said all of that, there are a ton of corporate partners out there who are now creating venture arms separate and apart from the corporate partner itself, which act more like financial investors who take equity in the company in exchange for cash, and interests are more aligned in that sense because they see the growth of the company from an equity investor perspective as opposed to only from how it might benefit the corporation from a products perspective or something like that. So those are the from whom's. Then we get into the types of financing. And this varies significantly depending on stage of company, how much you're looking to raise, et cetera. So the typical ways that we might raise capital, maybe I should rephrase that. The traditional way to raise capital is something called a priced equity round. You sell common stock or preferred stock at a set valuation for a specific amount of your company, a specific percentage of your company. You might know that venture funds, generally speaking, prefer to invest in priced equity rounds of preferred stock. I don't know, maybe 10 or so years ago, it became clear that early stage companies doing priced equity rounds, the transaction costs were very high, and it was very difficult to value a company in such an early stage. You're an early stage company, valuations are very difficult to determine. It's a little bit like a guessing game. You have very few observable performance metrics with which to determine value, etc. So enter the convertible note. The convertible note is a debt security, so it goes on your books as debt, but it's really not intended to be a debt instrument. It's really intended to be an equity play in the future. So a convertible note will say, I, the investor, will invest X dollars in you company, and in exchange, I will get a debt instrument with a relatively small interest rate and a maturity date of somewhere between a year and 2 years. But if you do a qualified financing, which is an equity financing of a certain size, then I will automatically convert my convertible note into whatever equity security you issue at that next round, usually at a cap or a discount, whichever one nets the investor more shares. So a typical a typical discount for an early stage company is somewhere between 15 and 20%. 20 is pretty standard. And a cap varies depending on how early stage you might be, but a cap is effectively the ceiling at which the convertible note holder will convert. So convertible notes, they had a place in the market and still very much do, but very smart investors recognize that this is not meant to be a debt instrument. Putting it on the books and records as debt is not exactly what the intent was. And so they created something called a SAFE, or a simple agreement for future equity. Unlike a convertible note, a SAFE is not debt, has no maturity date, has no interest rate, and it's just a contractual promise that I, the company, agree to give you, investor, whatever equity security I grant at the next equity financing, still usually at a cap or a discount, whichever one nets the investor more shares. So a SAFE basically just sits there until you do an equity financing. And it's an attempt to align form and substance, because the reality is when you had a convertible note, if you hit the maturity date and haven't done a price equity round, the reality is you probably won't, and that money that is supposed to be repaid at interest or with interest at the maturity date, it's gone, right? The company has used it, and it's not secured generally, and so it just sits there as an unsecured loan. The company, if it doesn't do an equity financing, may not survive, and if that's the case, the investor loses on that investment. The SAFE tries to align form and substance in that it's not a debt instrument, there is no maturity date, and if and when the company does an equity financing, the SAFE holder will convert into that financing, but if it doesn't, then nothing happens. Institutional investors hate SAFEs, almost invariably. So depending on who you're raising money from, that might help to dictate which type of security you issue. If you're raising over $1 million, then the investor's probably going to want a price round. Somewhere less than that, if it's coming from institutional investors, they might want convertible notes. If it's coming from friends and family, angels, certain others, they might be willing to do SAFEs. But know who you're pitching when doing this, and so you don't go to the wrong person with the wrong security, showing a lack of understanding or knowledge. I think we talked about the next point already, the return of price equity. I mentioned this earlier. Venture funds have come down market quite a bit because they have recognized, among other things, that because of declining capital intensity and the cost of creating a business, you can raise far less dollars and still have a really nice exit as a venture fund. So a lot of these investors have come down market, are willing to invest earlier in the life cycle of these early stage companies, and if they invest $250,000, I'm making numbers up, and you have an equity or an acquisition of $50 million, that could still be a home run. We don't need every company to be a unicorn in order to have a really good exit for companies. And so investors have come down market. We created for one of the most active accelerators in New York something called a pre-seed preferred stock investment agreement that has become very common nowadays. The idea being that we want to reduce transaction costs in the early stages. Companies, the transaction costs associated with a deal have to align with the amount actually being raised by the company. It strips away some of the bells and whistles that you might expect from a typical venture capital seed or Series A financing. And basically, sometimes we'll provide a most favored nation provision where the investor will get those rights if the next equity financing investors receive them or receive rights more favorable. Brings transaction costs way down, aligns form and substance, and gets the QSBS holding period started for the investor. I mentioned this earlier, but QSBS does not start, that 5-year holding period does not start to tick until the investor holds actual priced equity. So convertible notes, safes, do not count until they actually convert into equity. So moving right along to the next slide, please. Immigration laws. I see a question right now about immigration laws, and I will preface by saying that I am not an immigration lawyer, but to the extent you have immigration questions or you are a non-resident alien or an international student in particular, you should certainly be discussing with Immigration Counsel. If you have any questions about that, again, I'm not the right guy to talk to, but there are people at our firm who focus in that space. Feel free to reach out and I can connect you. My basic understanding is that you can be a stockholder of a company and you can be a director of a company, but you cannot be an officer of a company unless you have the requisite work authorization. And so what that essentially means is that you can't be an employee of the company unless your work authorization allows for it. So please do consult with Immigration Counsel, and I'm happy to connect you with ours. Next slide, please. All right, so Bill's asked that I provide a couple of case studies to highlight some of the things that early stage companies are doing, things that we're helping with. Here's one, not unlike a Mount Sinai company where the technology emanated from a major institution in New York. The company was formed in order to commercialize that technology. So we created our starter kit. There were 6, I believe, founders of the company, all students or faculty of this university. So we had to work out with the university a license in order for the company to commercialize the technology. Here's one of those don't do it right the first time. They did not get some of their starter kit documents signed, including invention assignment agreements. And then one of the founders wanted to leave the company, hadn't assigned his invention to the company, and also hadn't signed the restricted stock purchase agreement, which subjected him to vesting. So he left the company with, I think it was 1/6 of the company, which was a lot of equity to walk out the door for someone who hadn't really provided a lot of services yet. So we had to negotiate a separation agreement with this company, redo all of the starter kit documents. We cleaned it up, but it was a mistake that could have been avoided with added costs associated with that. This company then did a $1 million venture raise from an accelerator's venture arm, and then later joined the accelerator, which is backwards from the way it normally goes. But we reviewed all those documents, drafted the pre-seed preferred stock investment agreement, as I mentioned before, and understand that when you raise money from an accelerator or when you join an accelerator program, these are largely contracts of adhesion, take it or leave it type contracts. But of course, You want to review them, make sure that they're standard, because depending on who the accelerator is, some of them have some funky provisions. We're now helping this company with its patent strategy. That's not me personally. I'm on the corporate side, so the venture stuff primarily in the M&A work, but our patent folks are helping this company with its patent portfolio. The next slide, please. So this was not a dissimilar situation. The company raised a fair amount of seed capital from active venture funds. We drafted all of the financing documents for them. Now, here was a situation where the company had a really great founder who was the CEO, who was clearly the right person for the job from the incorporation stage through some of the growth stage, but he was maybe not the right person to take it from growth to massive growth, or I could probably say that more artfully. So they fired their CEO. This was largely at the behest of investors who, as I mentioned, when you bring them onto your cap table, are going to have a pretty large voice in how the company operates, and is a sort of a case study in why you might be careful with who you raise money from. So we dealt with that. Again, a separation agreement for the CEO. He got some severance as a result, maintained a fair amount of equity. The company has received, I think, 2 acquisition offers at this point, but they weren't the right deals for now, so they continue to grow and operate. We're helping them on the things you see down there: general corporate, IP strategy, employment-related matters, tax issues, immigration, etc. I think that might be our last slide. So I'm happy to take questions now. And I think I saw a comment on sharing these slides. I'm happy to share them if Mount Sinai is, or to the extent people have questions, please do feel free to reach out to me at the number there or the email address there. I'm happy to talk with any one of you. And I thank you for your time.
Okay, at this time, if you do have questions, please feel free to write in the chat. Jared, we will be organizing with Jared a group office hour sessions for Mount Sinai inventors and innovators. Time and place still to be determined, especially considering the coronavirus outbreak. And with that, again, please write in the chat if you have any questions. And again, we'll try to figure out a way to send out something where the slides and the content. We still have to review the recording of this particular primer before any distribution. Jared, out of curiosity, in your experience, figuring out with the university early on, with founders figuring out earlier on with the university and how to kind of work out the IP and what's what. What have you seen? Stuff that's gone right and stuff that's kind of gone wrong when founders try to circumvent IP policies and maybe not try to maybe not play 100% with the university that they're clearly doing the research in.
Sure. It's a great question. I think there are certainly cases where people do intentionally try to circumvent their IP requirements. I also think that there are a lot of people who just don't realize what they have signed when they are employed or engaged by a major university. And so part of this topic, I think, or at least I hope, sheds light on the fact that you are likely bound, if employed by a university or even a different employer, right? If you've signed an invention assignment agreement with a different employer, you have to be careful about what you create for the company and assign to the company. So I think open discourse is obviously important. Understanding who owns what is important. It's also important that whatever the founders or team creates that is owned by the university is ultimately licensed to the company if the goal is to commercialize, because the value of the company does need to be with the company in order to grow and scale and attract investors. So universities have a very important role there in facilitating that. And then also important, understanding what has been assigned to the university, but then also once you do leave the university, if and when you do leave the university, and you are full-time with the company, making sure that you and others have assigned appropriately whatever was not covered by the university IP license, you assign that technology as well to the company directly.
Okay, thank you. That's very, that's a good answer. So we have a question from Tiffany here. It's a multi-step question. So I'll start with the broadest one. At least from your perspective, and this is not coming from per se university standpoint, when is the best time to create a startup?
Sure.
That's the bit, yeah.
So I see your 3 questions here, and they're great ones. First one, when do you start the startup? I think the canned answer is if you're operating in your basement, not involving any third party, not entering into any contracts, right? You're really in the ideation stage and figuring out whether the concept makes sense. You may not need to form an entity just yet, but as soon as you start doing business with others, bringing in third parties, engaging with contractors or others, it's very important to have an entity for the reason that I mentioned, I think, at the very first slide, which is to protect your personal assets. Until you form an entity, you are personally liable for the obligations of the business. So if you enter into a contract with a third party and that person sues the company for whatever reason, good reason or bad reason, or no reason, that person is suing you personally and can come after personal assets. That's not a good result. We want to make sure that we're protecting you and your personal assets. So definitely think about forming your company before you start to engage outsiders. And I would say sufficiently before you are going to raise capital. I see your next question is it just before requesting capital? And I think you want to do that sufficiently far in advance of raising capital for one primary reason. When we form a company, we want the founders to take their shares at nominal value, right? You pay that 0.0001 cents per share, the fair market value for the company stock. You pay that money, right? Everyone must pay at least fair market value for equity in a company, or there will be tax liabilities. So if you pay fair market value and you take your shares, let's say you take 1 million shares, I'm doing math in my head here, at 0.0001 cents per share, you've paid $100 for your shares, and the tax on $100 is nominal, right? The fair market value at the time of formation is truly nominal because you haven't actually done anything yet which builds the value. Obviously, the idea is important, but until you execute, the idea is not really valuable. So if you do it just before you raise capital, let's say an investor gives you a term sheet and says the fair market value for these shares is, the pre-money value before their investment, let's say, is $5 million. Well, now we have an indication of what current fair market value is. And you, founder, would have to pay fair market value for your shares or have this humongous tax effect when, again, you have no cash coming in the door to offset it. So that's a very bad result. I want you to enjoy the appreciation and value of the shares from the first penny. And so we want to form the company, or we want the founders to get their shares as early as possible and certainly sufficiently far in advance of the capital raise so that there's no question that the fair market value is more than nominal value. And then in your last question, how many months needed to create a startup? Kind of a fun question from the legal perspective because we can do it in a week, not months. So that's from the legal perspective of forming the company, drafting the starter kit and organizational documents. Obviously, a lot more goes into that from the business side of things. Understanding the idea, making sure it is an idea that is actually a business. A very active venture fund client of ours is fond of saying that not every idea is a business, not every business is a financeable business, right? So you may have a great idea that's just not ready to be a business because it's not scalable or because it's too expensive to implement. Maybe a good example of that is before my time, one of the partners here represented an iris recognition software company that was basically putting iris recognition software cameras on ATMs about 15 or 20 years ago. The technology was great and could eliminate ATM fraud, but the technology was so expensive that it was actually more costly to implement the technology than the bank fraud that it was preventing. So not a good business if the cost associated with implementing the technology is more expensive than the problem it's solving. Now, fast forward about 17 years, and 3 years ago, we represented a company doing exactly the same thing, but for mobile devices. And that, using their software, is a far less costly technology. It is now being used in every mobile device of one of the leading mobile providers in the world. So it wasn't a business 20 years ago. It is very much a business now and doing extremely well. From a business perspective, yeah, you need to ideate. You need to make sure that this business has legs. But from a legal perspective, we can form a company, within a week max. And so I hope that answers the question.
That's perfect. And Jared, this is assuming that again, the answer is assuming you're not part of a system like Mount Sinai, where you might, if again in a situation like this, Stefan, again, if this is a technology that you're working with or ideating out of the institution, this is something you work with Mount Sinai Innovation Partners to essentially see if that's the best route for the technology going forward. And in terms of navigating some of the other nuances of employment and other commercial activities, you would obviously engage conflicts of interest to figure out if, again, if you should even be a part of or advising even another entity or have other commercial opportunities that are outside the institution.
Exactly.
Are there any other questions? Okay, so with that, I think we're concluding our legal primer for today. For those of you who are part of our Pitch Challenge series, next week we're going to be having a talk on Marketing and Branding 102 and Investor Relations, and that's going to be probably going to be another webinar. For those of you who are not in the program, on April 7th, we're going to be having a dilutive funding primer and panel with a group of VC angel investors and startup banks. It should be a good conversation with that group and kind of piggybacking on a lot of the items that actually Jared was mentioning today. If you have any other questions or concerns, you can always email us. My email is dov.shamir@mssm.edu. And we thank Jared and McCarter English again for sponsoring this event and obviously giving today's primer and perspective on these legal matters when it comes to startups and venture creation. Thank you.
Thanks, Tove. It was my pleasure. And please, anyone who has follow-up questions, do not hesitate to reach out. That's what we're here for.
Have a good day, everyone. Stay healthy.
Thanks. You too.